Can we put MG away, Mr. Hussain?
Not just yet, my lady. I'm really sorry. It won't take too much longer on it.
I'm not suggesting you're taking too long, it's just impenetrable.
My lady, yes. I think so. We were in MG at paragraph 33, and I was seeking to make good my submission that the first part of paragraph 33 they cannot take into account is inconsistent with paragraph 35 because of the focus there in paragraph 35 on the 10-year period preceding the decision to expel. It is also noteworthy that the first part of 33 is not picked up in the operative paragraph, which is in substance paragraph 38, but it's there also in operative 2. And there you see it's the in principle provision, the in principle holding that is repeated. So the court says at paragraph 38, this is MS 885, a period of imprisonment is in principle capable both of interrupting continuity and affecting the decision regarding the grant of enhanced protection, even where the person concerned resided in the host state for the 10 years prior to imprisonment. So that is inconsistent. Well, 33 is inconsistent, we say. The first part of 33 is inconsistent with 35 and is not picked up in the operative part of the paragraph. But 35 and 36 are important, not just for the inconsistency to which I pointed out, but also to show how the court looks at imprisonment, because what it does, we see from 36, is that it situates imprisonment as one factor amongst others, not a dispositive factor, or indeed a near dispositive factor. I've already taken you to 35, and it's in that regard, so in regard to the 10-year period, that the court says that you've got to look at periods of imprisonment, take them into account as part of the overall assessment. That's 36. And then it's 37, which then extends the time frame backwards to the 10-year period prior to imprisonment, and not just the 10-year period prior to expulsion. And that's very important for a reason that I will come on to. It's very important because of the timing issue. If you didn't have that, and you didn't have the Saccharidis overall assessment, then there would be a real potential for Article 28.3a to be emptied of practically all application.
But Mr. Hussain, 37 is quite clear that the basic inquiry is 10 years back from the date of decision.
Yes.
And 10 years back from date of imprisonment is simply a factor which may inform the result of that inquiry.
Yes. Yes, it's a factor. It's
quite.
Indeed, my lord.
Two different 10-year periods, have you?
I'm sorry? Yes.
Two different 10-year periods.
Yes,
If the rule is 10 years back from the date of the decision, 10 years before imprisonment can't have anything to do with it, can it?
Well, it may affect integration.
It's the integration point, isn't it?
Yes, exactly.
Well,
exactly. This is not the stuff of bright line rules. One can certainly say that. The contrast between this decision, however difficult it is to comprehend, the contrast between this decision and Onoquere could not be starker. Right. Onoquere, very clear, bright line rule, when you're looking at acquisition of RPR under Article 16, imprisonment cannot count, full stop, breaks continuity, full stop.
Yeah.
Bright line rule. This is at the opposite end of the spectrum in terms of nuance. And in that regard, we invite attention to 36, to paragraph 36, where we say imprisonment is but one factor amongst others that has to be looked at. And it's a specific treatment of the issue, which we would say takes priority over the more abstract propositions earlier in the judgment. And it contrasts, 36 here, contrasts with what the Secretary of State wants to say about imprisonment. So, for example, at her case, paragraph 46, just for your note, MS 116, she says, a period of imprisonment exceeding 2 years reflects unambiguously a lack of integration in the host society. What do we say about that? Yes, it does, for Article 16 purposes, arguably. If you're looking at acquisition, yes. If you're looking at retention, we take issue with a bright line automatic rule, but it really doesn't for this purpose, for purposes of protection from expulsion. There's a very good reason for that. I'll come on to it in a moment, which is that these are very two different things, as my Lord Wilson said this morning. Protection from expulsion is very different to eligibility for RPR, and there's academic authority to say that RPR is really about access to social assistance. My Lord was absolutely right. That's exactly what it's directed at.
Well, is it? Is it, Mr. Hussain?
I will take you to provisions which talk about...
I mean, it's certainly the context in which it has come up for examination.
Yes.
But is that the principal
Yes, it is.
objective?
It is.
All
It's
right,
what Professor
well,
Gill says.
well, maybe.
We've quoted the passage from her book. It's the whole point of it is that you are, once you've acquired it, you're released from economic activity in the broadest sense. And critically, you're released from not having to be a burden on the state.
Yes.
That's the whole point of it. And it's controversial because of that very issue. It doesn't of itself engage with any fundamental freedom movement. It's a novelty in secondary EU legislation. It's a novel, it didn't exist before this directive. Right. Very different when you're talking about expulsion, interference of the most basic and dramatic kind with free movement rights. It's completely different. And I'll develop that in a moment.
I'm sorry to...
Not at all.
You must come to it, but just let me get this question asked now. Do you agree or disagree with the proposition, which I think Mr. Palmer gave us, that if you've got an EU citizen who's here, shall we say, 6 months after arrival,
Yes.
if he's not complying with the Article 7 or similar conditions, never mind eligibility for social security, he can simply be removed?
I disagree with that.
You disagree?
Yes. The reason, because of Preamble 16.
Thank you.
And Article, I think it's 14.3 from memory, if I can just find my note. Can I come on to that? Or,
Yes, do it in your own time.
right, but I disagree with it.
Okay, that's helpful.
But just to reiterate, we contrast 36, where imprisonment is a factor, with the proposition of Secretary of State that it shows unambiguously a lack of integration in the host society. There's no support for that in the Article 28 context. And you've got the point about 37. You've also seen the operative paragraph. So we say in MG nothing whatsoever to suggest that if you hit 2 years imprisonment, you're precluded as an absolute rule. Nothing whatsoever to suggest that. It's not enough for the Secretary of State to say, well, this question wasn't addressed, because in the central authority, as Lord Justice Aikins put it, of Saccharides, and this authority, cases concerning Article 28, you just don't have anything saying to this effect. It's only in the completely different context of Article 16 and on Aquere where you have this kind of bright line rule. I mentioned the issue of timing. This global assessment in Saccharides and MG is absolutely essential, because otherwise one risks considerably undermining the effectiveness, the effet utile, of enhanced protection under Article 28.3a. Because since time is calculated backwards from the expulsion decision in those member states, such as the UK, where the executive elects to decide to expel at the conclusion of the prison term, the effectiveness of the provision would be very significantly diminished if there was anything approaching an inflexible rule that prison time broke continuity. Lord Justice Pill below at paragraph 68 referred to the obvious injustice in delaying the deportation order, and he held at 86 that a state shouldn't be allowed to defeat a claim by deferring the deportation order until the period of imprisonment has been served. Lord Justice Sedley, in the HR Portugal case, I won't turn it up, unless you want me to.
I mean,
Just give you the reference.
the trouble I have is that if we understand this in the sense that you're submitting, and I see why you're submitting it, the central focus is on whether there is a continuous period of 10 years residence prior to the deportation.
I don't agree. The central focus is on whether or not integrative links are
No, I mean, surely, when it says in paragraph 34, and indeed 28, that it must, the 10 years must in principle be continuous.
Yes.
And it must proceed, it says somewhere else,
Yes.
by counting back, that's 24,
Yes.
calculated by counting back from the date of the decision.
Yes.
And then having stated that, they then muddy the whole waters by saying, in deciding, in paragraph 38, in deciding whether something is continuous backwards from the date of deportation, you can look at all these other factors which actually don't bear on that point at all, really. I mean...
Can I very respectfully say that the answer to all of this was given in an observation by my Lord Wilson? Because he said, is the clue here that Article 28.3a doesn't use the term continuous? And we respectfully say that is absolutely the key point, because that caveat, that proviso, is added by the court implicitly in Sakaridis, explicitly in MG. Now, once it's added, it's limiting protection against interference with free movement rights. If it's limiting that, the limitation itself has got to be interpreted restrictively, and it must be tempered by the introduction of the concept of an overall assessment. That's how we would say, standing back, what is going on here. The reason you need the overall assessment, the critical question, my Lord, with very great respect to my Lord's great expertise in this area generally, is not...
In principle.
But not a bright line rule.
My Lord, in principle, in actuality, it's not the 10 years prior to the expulsion decision. That is not what any of the cases are saying. The cases are saying you have to conduct a nuanced assessment to decide whether integrative links previously forged have been broken by a factor. Absence, Sakaridis, absence plus imprisonment, Sakaridis, imprisonment, MG.
I can see lots of good reasons for saying that, because of the obvious point that people who've been here for 30 years and then get sent to prison for 2 may well be, in other senses, perfectly integrated.
Yes.
But looking at the language of 28.3a,
Yes.
whilst you're quite right to say that it doesn't say continuous,
It says previous.
it says the previous.
Yes.
The previous 10 years.
Yes.
Which is perhaps why the court seems to take it as read that you count back from the decision.
But you've got to mitigate
But if you do count back
Yes.
from the decision, you run into the problem that you've just identified,
Yes.
don't you?
of potential for abuse. Or even if not abuse, if there's no mens rea, if you like, to adopt an unhappy concept. If there's no intention, but the effect is that you've equally got the problem of emptying the provision of application. And Lord Justice Sedley made, I was going to say Lord Justice Sedley made that point. I'll just give you the reference, if I may.
Why couldn't they deal with the whole problem under the proportionality? Because at the end of the day, I mean, even if they'd done what the wording says and applied it strictly, you've still got to ask at the end of the day whether it's proportionate to remove, and that would certainly bring in the fact that the man was born here and lived here for 100 years.
Well, because it does make a difference, doesn't it? Because the test is different.
What you've got happening
right.
here is you've got residual
I see that.
proportionality
Yeah.
under Article 27 and 28.1. And then you've effectively got a pre-proportionality assessment because of Sacharides and MG to determine what the criterion is.
Yeah, no, I see.
And the reason for that is that this is a directive aimed at strengthening the rights of free movement. And the principle at play in recital 24 is that the longer you've been here, the greater protection you should have. Now, there's going to be a lively contest between myself and my learned friend about the interaction between 23 and 24. I say 23, recital 23 refers to people who have exercised free movement rights. And the argument against me is that runs through to 24 because of the opening word accordingly. We say, we respectfully see the force of that. I accept there is force in that. However, it's contrary to the points I made in opening. It's contrary to the language of the article itself. It's contrary to precedent. It's actually contrary to principle, we say. It has problematic consequences, and there is academic commentary against that. 5 reasons, which I'll develop. But that's the answer to my Lord Mance's question. That the reason you don't just put it into proportionality is because, as my Lord Hugh says, you alter the test. Now, I'm going to give you the reference to Lord Justice Sedley, if I may. It's in HR Portugal at Volume 1, Tab 5, MS 678 at paragraph 43. Now, what he said, we've got it in our printed case if you want to do it more quickly that way. Our printed case is at paragraph 25, MS 134. He said, unless member states routinely order deportation at the start of a sentence, as some it appears do, problems such as the present one will remain. So he saw the potential for injustice then. Lord Justice Carnworth, again, I'll just give you the reference, indicated that the practical value of this provision was much reduced, as he put it. This is the LG Italy case to which you were taken very briefly, and it's volume 1, tab 6, page MS 698, paragraph 80. Those instructing me, Mr. Lukmani has produced a table of responses from our member states in response to an email which his firm sent. And I can hand that up, but I can simply say that of the responses which he received amongst the member states, it's about, it's 4-3 in favour of what Lord Justice Sedley suggested. So perhaps you don't need to see the table, but we've got it if you want to see it. So
if you want us to take any account of what you've just said, we better see the table. And so, for that matter, Mr. Palmer.
What's it a table of, Mr. Hussain? Private
I
inquiries.
didn't make it clear. A request went out to asking at what point the expulsion decision was made. It's a very important point.
And who were they asking?
Austria.
No, but who in Austria?
Academics in those states.
Right.
Oh, wait a minute.
So it may not,
Thank you.
and
I mean, it basically means punishment, Austria. Is that an organisation, an NGO, or what? Anyway,
it's an NGO apparently.
okay.
But perhaps this isn't worth taking time over. But I wanted to simply highlight that there's a division of practice. I can make the point good without this.
Well, you are halfway through your time.
Yes, maybe I should hurry up.
Mr. Hussain, just very quickly, 28.3a have resided for the previous 10 years. Now, might we make a bit of sense of and be loyal to the Luxembourg jurisprudence if we say now resided here must be interpreted autonomously? Don't let our rather prosaic notions about people residing in this country come into it. Residing here really means a degree of integration.
Oh, absolutely.
Pursuant to the overall assessment.
Oh, I accept that. I accept that. It is bearing in mind that imprisonment doesn't break that. It's not inconsistent with it for the purposes of 28.
Very well.
The reasons I gave. But yes, autonomous approach is appropriate. Just on the issue of timing, the Secretary of State says...
Well, just before you leave that point, I'm not sure can I just be clear as to what your position is? You gave an example earlier of somebody who might have lived in the UK, not in prison, for 8 years, and then spent a year in prison.
Yes.
And then been at liberty for another 2 years.
Yes.
Now, one way of looking at it is to say, well, the period in prison interrupts the continuous period of 10 years, but that's simply a factor following Zacharidis, and one can have regard to the 8 years and conclude that applying some sort of proportionality assessment, the requirements of Article 28(3)A are met. Another way of looking at it may come down to the same, may boil down to the same thing. Another way of looking at it might be to say, well, is he to be regarded as non-resident when he's in Pentonville? That might depend on the quality of his connection with the UK. Just as, if he left the UK on a protracted stay in Samoa, he might nonetheless continue to be resident in the UK. I'm sorry, which is your position, the first one of those?
I'm not sure that it matters, but I'm worrying that I've completely missed the gravamen of my Lord's point.
Well, it's really, are we focusing on the 10 years preceding the decision?
Yes.
I mean, if we are, if those are the 10 years we have to focus on, then you have to bite the bullet that there is a year spent in prison.
Sure.
And so on. And so you can't, in that event, sort of count the years which are more than 10 years ago, the residence more than 10 years ago. Rather, you're having regard to it as yielding the consequence that the year spent in prison is nevertheless to be regarded as a year when he was resident in the UK. Whereas your other approach is to say you can actually look at, provided you've got 10 years, going back however long it may be,
yes.
That's good enough if the periods in prison can be ignored.
I think you do both, with the caveat that when you count back, it's not dispositive. The fact that you've got 10 years pre-imprisonment isn't dispositive. The court's saying that in 37. If it was dispositive, I'm saying this against myself in a way. If it was dispositive, 37 would have said so. And it would be inconsistent with the fact that you count back from the date of the expulsion decision.
Yes, I mean, I'm asking because I understood your submission earlier to be effectively that you were counting towards your 10 residence, which was more than 10 years ago. And my feeling, reading what the court said, is that that's not what you do. You are actually focusing on the 10-year period, but whether periods in prison during that 10 years count may depend on the bigger picture.
I'm not sure it makes a difference, but we would respectfully submit that the primary focus is on the 10 years. If you don't get home on that, then you look at a broader time frame, 10 years before the imprisonment if you've got it. I think that's what I would say. I'd be happy to say that I don't accept that the exclusive focus is the 10 years prior to the expulsion decision.
Yeah.
But even if it is the exclusive focus, and you're looking at earlier periods of time with a view to informing yourself as to the impact of the imprisonment within that 10-year period, then we would say there ought not to be a different result, because what you're doing, basic principles of construction, you are approaching a provision which is giving protection against interference of the most dramatic kind with free movement rights.
And there's a sort of logic to it, because if the reason for ignoring time in prison is because it demonstrates a lack of adequate integration, and if the point of looking at the bigger picture is to decide on the degree of integration, then one might have thought the bigger picture might bear on what the impact of imprisonment actually was on any conclusion about integration.
Yes, I hesitate to put anything in my lord's mouth, but I'm not sure if my lord is. We're happy with the debit-credit system, provided that it's very clear that credit, you can credit the 10 years, the primary 10-year period prior to expulsion decision, and also the secondary one prior to imprisonment. I was making submissions about timing, the timing of the deport decision. The Secretary of State deals with this at her paragraph 66 or 67, MS 122-3. And she says that effectively that she's required to wait at least 2 years before making a decision to deport. We respectfully submit that that is a highly fanciful submission, fairly extraordinary submission in great respect. And she says that the application of enhanced protection is defeated by the commission of the offence rather than the consequent imposition of a lengthy custodial sentence rather than deferment. And we would respectfully submit that the position can be very easily tested. If the Secretary of State didn't defer, would he have the enhanced protection? Yes, if the other criteria are met. So at least deferment is at least a cause, and we would submit it's an operative cause, undermining the effet utile, the provision. The issue can be further tested by saying, well, it is absurd to suggest that it's only sub-2-year sentences that attract 28(3)(a). It's the absolute opposite of that. In this case itself, there was a deportation decision in November 2004 that was withdrawn for no particular reason, it seems. And we see that from paragraph 3, appendix part 2, MS 265. That's the decision letter in 2007. It references the fact that there was a deportation decision made in November 2004 that was withdrawn. And there will be cases where, where that makes all the difference. Now, all of this, we respectfully submit, goes to show the great importance of the Sakaridis overall evaluation. On the relationship between MG and Sakaridis, we say, I'm sorry, I probably didn't make my submissions clear before the short adjournment. In MG, the court specified 2 factors that should be taken into account in carrying out the overall assessment, and they are imprisonment, we see that at 33, 34, 35, and the fact that the person concerned resided in the host state 10 years prior to imprisonment. We see that from 37. So in a sense, MG concretizes the overall evaluation in those 2 respects introduced in Sakaridis. I also wanted to just give you a reference to Lord Justice Pill. Lord Justice Pill at 97 in his judgment expressly refers back to his paragraphs 80 to 86, where he summarises the history. Then, my lords, my lady, may I go to our second principal submission, and this is the issue of whether or not RPR is a necessary condition for enhanced protection. I'm going to spend some time on this and take my remaining 2 points very shortly. But this is clearly an important point. We say it's clear in our favour, but if it's not, it's certainly apt for reference. Your lordships, my lady, will have seen the language, the obvious contrast in the language. 16.1 refers to resided legally. 28.3a refers simply to residence. And your lordships, my lady, have the principle that the language of the directive shouldn't be interpreted restrictively.
But it's got to be residence pursuant to some sort of right. What right do you say that your client
Well,
was resident pursuant to? Hasn't it? I mean, if you look at the title to the chapter.
well, that's an indication. We don't accept it's governing. It doesn't support the idea of having retained permanent residence for the reasons my lady gave. It doesn't say permanent residence.
So you say it might just be what? That he was intending to work?
Well, I say two things. It could just be residence pursuant to Article 7 without permanent residence. That's one.
Would your client fit into that?
Yes, because
He's a family member, isn't he? He's a family member, isn't he? Got a wife who's a teacher.
Yes, because of Surinder Singh. Yes.
I see. They haven't divorced or anything. And anyway, even if they had, you say that he'd have the protection.
Well, yes, but my principled answer to my Lord's question is the point that my Lord Wilson put to me, which is that you give the term residence an autonomous meaning, which includes an element of integration, but but not in a formal sense.
Is it good enough to be a family member if you're separated? You've got to be a family member accompanying or joining a union citizen.
No, if you look at the retention provisions in Article 13,
right.
It's very clear that if you've been married and you're then divorced, you retain rights of residence. And then
you not the rights, quite right.
And you also, it's 13.1, you retain rights.
Yeah.
You can be eligible for permanent residence if you comply with Article 7 conditions, but then 13.2, if your marriage lasted for 3 years or more, and you resided in the host state for 1 year or more, then you have an easier eligibility for RPR.
But can a European citizen be present in this country unlawfully? Presumably they can.
Yes, they can, and I'll show you why.
Right, well, if they can.
Yes. But by unlawfully, do you mean not in the sense of the directive, i.e. not exercising?
No, I don't. I mean not allowed to be here at all.
Well, the Secretary... The Immigration Act doesn't apply to EA nationals.
Precisely.
RVP. They're subject to a discrete legal order of EU law. So, do you...
Well, you presumably can be if you don't satisfy the...
Well, then...
Rights residence under Article 7, read with,
yes,
as you say.
That would be unlawful in the sense of the directive.
Yeah.
But
and
if you're
therefore not qualify for 28.3a?
Our principal... We have two submissions. First of all, you don't need RPR. Secondly, you can just be resident.
Pursuant to Article 7, yes, I see.
So you say there's no requirement of right of residence at all under Article 28?
Yes. That is...
You say there's no requirement of a right of residence. I thought you said that there was a requirement of a right of residence, but it didn't have to be a right of permanent residence.
That's one submission. The other submission, the wider submission, is that you don't need a right of residence at all. The courts never said that you do. It's not in the language. And if you look at Sakaridis, we say that we can get a lot out of it, because what Sakaridis is saying in terms at paragraph 31 is that the decisive criterion is whether you've lived here. And Sakaridis is at volume 2, tab 9, at 766. The judgment begins at 785. Can I just take you to the fact, because I want to meet one point that my learned friend made. He said that it didn't matter that Mr. Zacharidis was absent for a combined total of 34 months or in prison. We get that by seeing at paragraph 11 that in mid-October 2005 he goes to Rhodes, and the decision to expel him, beginning of 13, is August 2008. So that looks like 34 months of a combination of absence from the member state and then imprisonment. And my learned friend says, well, never mind that. In his printed case, he says, look, individually the periods of absence and imprisonment are less than 2 years. So we say that misses the point that you can aggregate them. The Secretary of State's case is that imprisonment is the same for these purposes as absence, so we say you can aggregate them. He then says in oral submissions, well, if you look at April 2006, at that point, he hadn't been absent for more than 2 years. But that's irrelevant because he is relying upon pre-2006 residence. Post-2006, he's either abroad or in prison. So if my learned friend is right and there's some sort of automatic loss of permanent residence, it would bite here. He has to rely on residence pre-2006. He is a transitional case. And yet, what we say is a striking feature of the narrative is that we see that the court does not regard that he'd lost his right of permanent residence. We see that at the bottom of 19. Now, I entirely accept that this issue wasn't before them. I accept that. But what was before them was the relationship between permanent residence and when you lose it, and eligibility for 28.3 protection. Now, my learned friend says the reason why the court rejected the analogy of 16.4 was that it wanted to be more generous to states, if you like, harder on the individual, and say, well, you could lose enhanced protection for imprisonment for less than, or absence for less than 2 years. Indeed, the Attorney General said that. The Advocate General said that. That's not picked up by the court, as my learned friend very fairly accepted. But we say that actually what the court is saying is that the provisions are just completely different. They're just different things. And we see that at 29, in the middle of 791. Article 28 makes, while making the enjoyment of enhanced protection subject to presence, is silent as the circumstances which are capable of interrupting, starting from the premise that, like RPR, enhanced protection is acquired after length of residence and can be lost, the referring court considers it may be possible to apply by analogy 16.4, and then the critical provision. So while recitals 23 and 24, those are the recitals which Lord Justice Stanley Burnton relied upon in HR Portugal, I accept that they give support to my learned friend's submission. I accept that. But the point is that the Grand Chamber rejects them as illuminating the meaning of the article itself, because it says, while those recitals certainly refer to special protection for persons who are generally integrated into the home state, in particular when they were born there, have spent all their life there, the fact remains that in view of the wording, the decisive criterion is whether the citizen has lived in that member state for the 10 years preceding. So the emphasis is on lived. And we respectfully submit that what the court is essentially doing is it's refusing to give this provision a purposive construction in light of the preamble, when to do so would restrict the protection which it confers.
Well, it's interesting that the operative part actually uses the word resided.
I was going to come on to that. I've highlighted in this case, and also in MG, you have it liberally in MG as well. I'll just give you some references. Paragraph 23, they repeat this. Decisive criteria where the citizens lived. 25 in MG, this MS 883 to 884, resided. There's nothing whatsoever to indicate that this is all predicated upon protection of RPR. And the other thing that's interesting, perhaps I should just take you very quickly to recitals 23 and 24, just to show, just to remind my lords, my lady, of the argument against me. As I keep saying, I can see the force in it, but it's inconsistent with the Grand Chamber authority. So you've got recitals 23 and 24 at volume 1, tab 2, page MS 513 to 514. At 23, it's line 2 that's critical for my learned friend, because that says expulsion of UN citizens and family members on grounds of public policy, etc., can seriously harm persons who, and then this is the important clause, having availed themselves of the rights and freedoms confirmed by the treaty, have become genuinely integrated. So the question is, does that clause govern 28, if you like? Because of course it governs, does it govern 28.3? Because obviously it governs 28.2. And at 24, accordingly, that's his bridge, the greater the degree of integration, etc. But that's not what the court is saying in 31. It's saying we're going to interpret the language. And I asked my learned friend, he very kindly took you to 31 in LaSalle, where the court says very basically, very trite, you don't construe these provisions restrictively. But then what's also interesting, my lords, my lady, is the way the Advocate General in this case regards integration. He doesn't regard it in the qualitative sense. He regards it in the temporal sense. It's length rather than quality.
Yes, but I mean, this is in support of your first submission that there's no requirement of any right of any sort at all under Article 28.3.
It is. It is.
Well, I mean, isn't that clearly a referable question if you have to go that far?
Well, I don't know if my lords and my lady think that, but can I make...
Well, I say you say it's that clear that despite the heading of the chapter, there's no need for any right whatever. It doesn't rise in this case, does it? Or perhaps it does.
It doesn't rise, you're right. Yeah. My lord's right. But can I just show you what the Advocate General says at 45? I see the force of my lord's point. Of course I do. Because, apart from anything else, there are contextual points pointing the other way. My Lord Reid said it's absurd. We've said in our printed case we can see that anomalies arise here. But the weight of the argument, we say, points in this favour. And the Advocate General at 45, at
MS
777,
yeah.
And this is Advocate General Bott, who's also he's in, I think, most of the cases. I think he's in, certainly on Aquere. So at AG 45, he says, the system described establishes the premise that the level of integration depends on length of residence. And he says the same thing at MS...
This is a generalisation, and he's clearly not right in relation to the 5-year point. And
he's not talking about...
well, I thought he is. He's talking about the gradation, isn't he?
Well, the reference to enhance generally means, my lord may be right, but reference to enhance, it generally means 28.3. If you look at the previous, well...
28.2 is an enhancement as well.
Yes.
Yeah. It certainly is, my lady. Yeah. But if you look at the previous paragraphs, he seems to be, well, he's talking about 28.2 as well as 28.3.
Yes, he is.
No, my lord's right.
I think, but, we can read these things, but none of them is act clear.
Perhaps I should then make... So that's Saccharidis on this point. We also say that the same result flows as a matter of principle because, as I've adverted to earlier, expulsion is a far graver interference with EU nationals' rights than a denial of RPR. It's the social assistance point that we use. Probably the quickest way of doing it is if I give you a reference to our printed case. It's MS 149, paragraph 93, where we cite Professor Gill's observation that at the centre of RPR lies access to the host member state's social assistance system. And that's very clear, we respectfully submit, from the very definition of 16.1, the point that you don't need to continue to fulfil the conditions. And you can test it by looking at somebody who is denied RPR, what happens to them. Their right of residence remains intact if they comply with conditions. And they also, this picks up my Lord Hughes's point, appear to retain protection against expulsion, provided they didn't become a burden. So if they're reliant on family members or so forth, and they don't become a burden on the state, then it seems as though, and we accept it's not clear, there isn't case law on this, but it appears that shouldn't be a reason of itself for expelling them. You get that from, I mentioned the preambles, I'll take you to it. Preamble 16, first of all, in the directive. So it's volume 1, tab 2, at page 511. And preamble 16, first sentence, as long as the beneficiaries of the right of residence don't become an unreasonable burden on the social assistance system of the host member state, they should not be expelled. And then if you look at Article 14, which is at 532 in the same tab, over the page, 14.3, 533, expulsion measure shall not be the automatic consequence of a union citizen's or his or her family members' recourse to the social assistance system of the host member state. So what seems to be being envisaged is a toleration, if you like. We accept that the right of residence is conditional on meeting the criteria, but there is an express provision that if you don't do that, and you're not an unreasonable burden, you shouldn't be expelled. And that's miles away from expulsion, which is the most basic interference with free movement rights. So there's very good reason as a matter of principle for approaching Article 16 on the one hand and Article 28.3 on the other hand differently. Now we accept, my lords, my lady, that integration in conformity with EU law is relevant to both RPR and eligibility for enhanced protection. MS says that. At paragraph 32, it says, since the degree of integration is a vital consideration underpinning both. But it doesn't follow that it's relevant in the same way. And that's conclusively demonstrated by MG itself, because I've made the point many times, and I'll just do it as quickly as I can now again. Imprisonment has a categorical or a dispositive effect for acquisition of RPR, see on a query, but it only has an in principle or an indicative effect on eligibility for enhanced protection.
Sorry, what was the first reference? It has a dispositive effect, and you referred to?
On a query.
Oh, on a query, thank you, yeah.
So dispositive for acquisition of RPR, indicative only, in principle, on eligibility for enhanced protection. So the very case which says it's relevant to both is also saying it's relevant in a different way to both. And you've got the language of borne in mind as well in MS. And my Lord Wilson made the point that, again, on Aquera itself, the same Advocate General Bott, in a passage which I have in my note, it's at paragraph 28, 214, MS 893 to 4. My Lord cited it to my learned friend. He says the conditions for the grant and loss of RPR must be distinguished from those relating to the loss of enhanced protection. These are different things. So those are submissions on principles, as to why these things are different. There's a consequential objection to the Secretary's contention, because you could have a situation, let us say you have it here, that RPR is lost following imprisonment in excess of 2 years. That would leave intact previous periods of legal residence. And why on earth should they not inform the question of whether you're entitled to 28.3 protection? So this is my narrower argument. My wide argument is that you don't need legal residence at all. Narrow argument is that you certainly don't need RPR for consequentialist reasons, because if you could lose, as my Lord said, you could have 30 years, a 2-year sentence of imprisonment. Okay, let's assume there's an automatic loss of RPR. Why on earth should not you be able to pray and aid your previous 30 years of lawful residence for the purposes of 28.3? Why should retention of RPR be the sine qua non of 28.3? When it doesn't say that, no court has ever said it, there are very strong reasons of principle why that should not be the case. And the other point, of course, is that we made this point a number of times. The very point of RPR under Article 16 is that you don't have to continue to reside legally, in the sense of the directive. It relieves you from doing so. That's the innovation in Article 16. And then in our printed case, we cite academic support from Professor Guild again for our proposition at paragraph 95, MS 149. And if you want the reference in her book, it's volume 2. I won't take it up. It's volume 2, tab 15, MS 961 to 962. But she says it's notable that unlike 16.1, there's no requirement in Article 28.3 that the prior residence must be legal or that it must be in accordance with the directive. In any event, there's no requirement to obtain permanent residence status before 28.3 is applicable. So even if persons within the scope of the directive can't qualify for that status, they could still obtain protection. It can even be argued any uses in the 10 years residence can obtain such protection, including persons who've only been permitted to reside on the basis of national.
Sorry, this is a completely different reference to the one you've given in your case. Where is it? 961 to 2, you're saying?
I hope it's not, sorry.
No, I'm just trying to find it on the page.
It is, right at the bottom.
Right
It's right at the bottom.
Oh, yes,
yes,
it's
exactly.
not one page, right. Yep.
And in our printed case, we accept that the contextual point is the other way, particularly based upon the relationship between 28, 2 and 3. But we essentially say that there isn't a linear progression. It's not that they're just different things. They're properly sound in the relevance of RPR, not its necessity. And we say there are you can invent anomalies on any. We cite Lord Justice Pill, the no Saccharidis limits the potential for anomalies. At the extremes, a short period of imprisonment won't itself defeat integration. Long period following a short period of imprisonment following a short period of lawful residence won't establish it.
Are there no other textbook writers?
I've looked for them, I haven't come across them. So, my lord, my lady, that just leaves the third and fourth points. So the third point is that there's no automatic loss. I'm on track, my lady. And our essential proposition is there's no automatic loss of an acquired RPR, even when that prior acquisition is notional or virtual. And there are essentially two reasons. And the two reasons are, I can take this fairly quickly, that where you're dealing with a notional loss, the language of Dias and indeed LaSalle is not a bright line language. It's the point my Lord Wilson made right at the outset of my learned friend's submissions. Can we just quickly go to LaSalle? So LaSalle, you have at volume 2, tab 8, at 733. I just want to remind you of paragraph 45 in LaSalle. So here, my learned friend, in fairness to him, also indicated this to you, that 16.3 was considered irrelevant because 16.3 is about acquisition rather than loss. And so there is a virtual world here in these cases. LaSalle and Dias are both about pre-2006 residents. And the court is, although of course you only acquire RPR in April 2006, there is a virtual analysis being conducted where the issue is, does 16.3, 16.4 apply analogically? And the court says, yes, it does. 16.4 applies analogically because you've accrued 5 years. 16.3 does not apply analogically for the same reason. You've accrued 5 years. On a quere, on the other hand, is a virtual acquisition case because he never had 5 years. His imprisonment in September 2004 was 2 years too soon for him because he'd exercised treaty rights from December 1999. And that distinction between loss and acquisition is really basic to EU law. It's very basic in Article 16. One can put it this way, that it is much harder to acquire RPR in the face of absences than it is to lose RPR because of them. And if your lordships, my lady, just look at 16.3, 16.4, it's very obvious. But it's a basic principle. Acquired rights. So that's LaSalle there at 46. Just one other reference at 56. And the phrase I would like to stress, if I may, occurs at the end of 56, where the court is discussing the analogical application of 16.4. And it says that if a state wasn't able to rely on 16.4 to periods of pre-2006 residence, then member states would be required to grant the right of permanent residence, even in cases of prolonged absences. And then this is the phrase, which call into question the link between the person concerned and the host member state. That is not, we respectfully submit, the language of a bright line rule even then. And we will see that this is then carried through in Dias. Dias is 2 tabs on, tab 10, page 798. And the relevant paragraphs in Dias are on page 831, and you'll see the reference in paragraph 61 to affecting the link of integration, absences from the host member state of less than 2 consecutive years are not such as to affect the link of integration. And then that reasoning in LaSalle, absences in LaSalle, is applied by analogy to residents not in conformity with EU law at 62. And 63, we say, is important because, again, you've got language which isn't, we say, the language of a bright line rule. Even though 16.4 refers only to absences from the host member state, the integration link between the person concerned and that member state is also called into question. Called into question. In the case of a citizen who, having resided legally for a continuous period of 5 years, then decides to remain in that member state without having a right of residence.
Well, what do you mean by the words, the right of permanent residence shall be lost only through absence? You mean it shan't necessarily be lost even by absence, or even by equivalent?
When the moment you're applying 16.4, analogically, there is room for manoeuvre. Even if there isn't room for manoeuvre, when 16.4 is being applied directly.
I mean, that's not applying it by analogy, that's applying a different rule.
Well, my lord, if you think about it this way, what does 16.4 say? 16.4 says absences only.
Yeah.
So that is applied by analogy, and it's extended, not just to absences. LaSalle is about absences, but Dias isn't about absences. Dias is about...
Right. But
so you're applying it by analogy, you're changing it. And I'm saying...
Of course you are, but you say you change it twice, in 2 respects. You don't just apply it to a different subject matter, you apply a different rule.
Well, you've expanded it in one area, and why would you not, on basic principles, leave room for manoeuvre to make something which is ostensibly mandatory permissive?
Well, because that's not what the rule says.
Well, the rule also doesn't say that it applies to people who haven't been active.
I see. Right.
I can't put it that way. And we say the language of the language of the court. I understand the force of my lord's point, but the language of the court, it leaves open. I respectfully submit that argument to me, because it's tentative language affecting the link called into question. 63. And onequere is different. We respectfully submit, because it's a true acquisition case. Onequere, you've got it 214 887, and you'll see you've already got the reference my Lord Justice, I'm so sorry, my Lord Wilson pointed this out, AG 28 at 893 to 894, Advocate General Bott is saying this isn't Sakarudi's territory. The court in that case was asked not to explain the concept of legal residence, a concept which is furthermore absent from the wording of 28, but precisely to, he means that 28.3, but precisely to interpret the system of protection against expulsion established by that provision. The conditions for the grant and loss must be distinguished, etc. And then you've got, my lord, the references in the court's judgment, which begins at 899, to the acquisition provisions. And we see that in operative 2 and 32.
MS?
MS 904 and 905, they go out of their way to refer to 16.2, even though the upper tribunal didn't refer to that. The upper tribunal's question 2 is at paragraph 16, page MS 902. There's no reference there to 16.3, but that is what the court regards the issue as being. It's a virtual application of 16.3 because he also needed to rely upon pre-2006 time. And we see the references of 16.3, paragraph 32, page MS 904, and operative 2 at the top of 905. And I accept that there is a reference to loss. There's only one reference to loss in this judgment, to loss of RPR, and that's at 25. Everything else is concerned with acquisition. It's an acquisition, it's a virtual acquisition case. Sorry, it's a real acquisition case as well as a virtual acquisition case. And there is a reference to justifying the loss of the right of permanent residence, but that refers back to Dias. You'll see that in paragraph 25 at 903. And again, we rely upon the language of Dias. We say the court cannot have meant to enshrine a bright line rule for loss. So that's the first reason why we say there isn't automatic loss. The cases upon which the Secretary relies in the loss context don't establish an automatic rule. The second reason we say we deal with in our printed case is that is, if the Secretary were right, Sakaridis would have lost RPR. He didn't. And also the individual in PI, I won't take you to it, but just give you the reference in our case. It's the printed case, paragraph 58 at MS 141, where the facts are, again, I think it's common ground. Two things are common ground. Firstly, that they didn't look at this question. We accept that. And my learned friend accepts that the result is inconsistent with his proposition. If remand time is counted, and he was convicted of very serious offending.
Well, it's pretty weak when you're relying, isn't it, on things which weren't argued. We can.
It's a make-weight point. I would say it depends.
Yeah.
So sometimes something's not argued because it's not arguable, but it depends. I don't mean to be facetious. I'm so sorry. Lord Justice Pill said that at paragraph 80 that 2 years imprisonment may have some value as a marker, but no more. And that's what we say the position is when you're looking at loss. But that really isn't the main territory here. The main territory, obviously, is what does one do with enhanced protection. Then we address our fallback. I'll do it very quickly. A fallback position on proportionality, 103 to 104, MS 151. I accept that the proportionality exercise hasn't been conducted, but we say, given the passage of time, given the proposition of Lord Justice Pill that the principles concerning proportionality would operate heavily in Mr. Vomero's favour, and given that this is not a context where one looks at the ordinary Article 8 exercise, because as certain of my lords, my lady, will be very, very well aware, after a number of cases this year, in Strasbourg, in Article 8, the starting proposition is the individual doesn't have a right to enter, whereas that's not the position in EU law, and we've given a reference there against Professor Guild. The starting place in Article 8 cases concerning third country nationals is entirely different than in EU law, where the individual has a right of entry and residence. And of course, Mr. Vomero, on the preserved findings of the Court of Appeal, has that. I referred a moment ago some time ago, to the proposition that Mr. Vomero didn't receive some sort of windfall, because there's a very cogent basis for the court saying that he was exercising treaty rights. That wasn't the basis on which the court proceeded. The court proceeded on the basis of unfairness. But I mentioned Surinder Singh. I don't know if you would like me to give you just references in the bundle to where the Surinder Singh principle is engaged, and I can also give you a case, I'm afraid it's not in your authorities, of a recent elaboration, a case called O&B, of the Surinder Singh principle. I don't know if you'd like me to do that very quickly or not.
Well, I think we'd like you to finish your submissions in time with the timetable.
I thought I was 2 minutes in time.
You are 2 minutes in time. If that's the last thing you want to do, by all means.
May I just give it to you very, very, very briefly? In a sense, it doesn't arise because you've got the preserved findings, but I'm doing this for forensic purposes, as it were. So Surinder Singh, the reference, his wife, then girlfriend, is a British citizen living in France for approximately 2 years, where she works as a chambermaid in a hotel, and that is MS 277, paragraph 3.14, and MS 425, paragraph 3. She then is an EU national returning to the UK in January 1985, who then starts to work a short time later as a teacher. He is by then her family member, having cohabited with her in Nice. 2 years after they met, he returns, and then they marry here in August 1985. The principle in Surinder Singh, of course, is that a national of a member state who has gone and created family life abroad to another member state, who then returns to the host member state, his own member state, is regarded as a free mover. So what it establishes is that the beneficiaries of free movement rights are not only nationals or member states residing in other states, but own nationals who are returning to the home state, having exercised treaty rights abroad. That is his wife. And then the principle is developed in a case called O&B, which effectively brings national of the host state in that position within the scope of the directive. We don't need to make that good because you have the preserved finding. I'm simply giving it flesh and indicating there's a very cogent basis upon which he can be regarded up to divorce as being here exercising EU law rights. It wasn't how it was put before the Court of Appeal. It was put on a different basis of unfairness. There's also a self-sufficiency issue. He could be regarded as being self-sufficient if she, as a teacher, had insurance, or there were reciprocal arrangements between Italy and the UK in terms of insurance. That hasn't been investigated because of the age of the issue. But the Surinder Singh is a very robust basis on which he can say, if he was put to proof, we say there would be a very good case there. Those, my lords, my lady, are my submissions.
Thank you very much indeed. I don't think there are any more questions to put to you. Professor Tridimas?
Nothing to add.
Aye, my lords, I think I have 4 brief points on which to rely in the remaining quarter hour. I'll start with one of the points close to the end of my own friend's submissions, when he was, it was his 3rd main heading, which was effectively headed "No automatic loss," was the point he was making. And the point that he sought to advance was that the cases of LaSalle and Diaz did not impose a bright line rule. The essential thrust behind my learned friend's submissions are these. He invites the court to divide the cases, the authorities to which you've been referred, into 2 categories: loss cases and acquisition cases. He says on inquiry is an acquisition case, you have a very bright line there, he accepts. He says loss cases such as MG and Saccharides are clearly more nuanced approach. And the effect of his submission is he seeks to put Diaz and LaSalle into the same sort of category as MG and Saccharides. And I say that is simply wrong. They fall into a bright line case. We could argue about whether you refer to them as cases in which discussing whether a right of permanent residence was acquired or whether a notional, virtual, yet to be crystallized right was lost. But it's certainly in each case, LaSalle and Diaz, we were in that pre-2006 territory. In each case, the court did decide that Article 16.4 should be applied, the rule, to put it in the language of the court, the rule in Article 16.4 should be applied by analogy. They did not decide that a different rule should be applied because of some sort of analogy beyond that, but specifically that the rule in Article 16.4 should be applied, and that is a bright line test. Perhaps I can just give you the one reference where it's summed up, which Mr. Hussain did not take you to, either in his oral submissions or indeed in his written case, which is paragraph 65 of DS. I won't take you to it now. It's a page 831 to 832, because we saw it in my earlier submissions. But that is the language of the court where, having earlier referred to the fact that these rights of residence must be called into question, then concludes that the rule must be applied. And there is nothing tentative about that language. That is why, to return to a point made at the outset of my learned friend submissions, in Authorities Volume 1, Tab 3, in the 2006 regulations at MS 617, where we are in Schedule 4 of the regulations, paragraph 6.4, you may recall that it was suggested to the court that misinterprets or misapplies the directive because it applies a bright line rule that periods of earlier, 5-year periods of earlier legal residence before 30th of April 2006 will not be regarded as a period during which that activity was carried out in accordance with the regulations, where it was followed by a period, and then A, which exceeded 2 consecutive years and for the duration of which P was absent from the United Kingdom. Just pausing there, I simply say that implements LaSalle correctly. Or B, which exceeded 2 consecutive years and for the duration of which P's residence in the United Kingdom, Roman 1, was not in accordance with subparagraphs 2 or 3, in other words, was not legal residence in the treaty sense. That implements Diaz. Or 2, was not otherwise in accordance with these regulations. In my submission, that would include periods of imprisonment, because periods of imprisonment we know from all new query do not constitute legal residence. And so on the logic of Diaz, which was cross-referred to in our new query, would not be legal residence in accordance with the directive and would be treated in the same way under Article 16.4. So we say there's nothing wrong with that interpretation. It is a bright line, and it's right to take a bright line to those pre-2006 acquisition cases. That, we say, much is clear. I accept that in relation to post-2006 cases where a right to permanent residence has already crystallised, it is not yet clear on the existing authorities what the effects of a period of 2 years imprisonment would be. There are dicta in on new query at paragraph 25. Remind myself. 20, it is 25, that's right, which refers to the loss of the right of permanent residence, which suggests that it is possible that that right may be lost even once it has been acquired by virtue of a period of at least 2 years imprisonment. I do not submit to my lords that that latter point is yet clear. So that is the position on automatic loss. The second main head to cover is the question of the relationship between Article 28.2 and Article 28.3a, and whether in particular Article 28.3a requires residence in conformity with the directive, or whether any residence will do. And secondly, my friend's second submission about whether a right of permanent residence is a necessary precondition to the enjoyment of rights under Article 28.3a as well. As to the first point, do you need legal residence in the sense of residence under the directive at all? My submission is that the answer to that is clear, and the answer is yes. You were taken in Authorities Volume 2 to page 777, which was Advocate General Bott's opinion in Saccharidis, and you were taken to paragraph 45, and the submission that was advanced was that simply length and not quality of residence is what is relevant for this purpose.
But that was preceded by 44.
My lady, it was. And it was preceded as well by the discussion I was going to take you, I shan't take time over it now, but from paragraph 35 leading up to that conclusion, the spirit and structure of the system established by Directive 2004-38, may I just point up 35 and 36, as a necessary precursor to all of this. We're ultimately talking about freedom of movement of persons being one of the fundamental...
The right of freedom.
Freedoms, the right of freedom of movement.
And residence.
As ultimately, as a treaty right, as applied in the directive, it's a limited treaty right, subject to the terms in the directive. When the European Court speaks about residence, this is the residence it is talking about. It has no basis to talk about anything else. It is the protection of the rights of entry and residence which are conferred under the treaty. From a qualitative point of view, it then is a matter of policy, as reflected in the recitals to the directive, as reflected in the case law of the court, makes the point that the exercise of those rights deepens integration, creates and then deepens over time the level of integration of a union citizen exercising that right. That is the context in which the language of residence is used, both in the judgments as well as in the directive. And that is why when you get to 44, to which my lady directed me, it not only refers there to the exercise of the right to freedom, but also in the very following paragraph 45, on which my learned friend relies, the bridge is the words, "that is why." And it's no coincidence that the court then uses precisely the same language at paragraphs 24 and 25 of its judgment. It's at page 791, where it again, at the beginning of paragraph 25, explains that is why. And so you were told there'd be vigorous disagreement between us as to the relationship between recitals 23 and 24, because my learned friend wants to ignore the reference to the exercise of treaty rights in 23 when he gets to recital 24 and the reference to article 28.3a. And that is wrong. It's wrong for the reasons which were explained by Lord Justice Stanley Burnton in the domestic authority that I took you to earlier of HR Portugal, who emphasised himself the bridge in the original language of recitals 23 and 24, emphasising that recital 24 begins with the word accordingly, again making that connection. So the fact of exercise of the rights of entry and residence does not fall out of the picture when you get to recital 24, and does not fall out of the picture when you get to article 28.3a. It's the only kind of residence with which the court is concerned and with which the treaties are concerned. And then when you come to the subsequent question, of therefore whether the existence of a permanent right of residence is required before you get to Article 28.3a, the answer must be yes, because as explained in Saccharidis from 23-24 onwards, paragraph 24-25 onwards, it's that pyramid, that escalator of protection, which builds as the level of integration deepens. And it cannot be right that someone who relieves themselves of the need to continue to comply with the Article 7 conditions of residence, thus acquiring a permanent right of residence, has less protection under the directive than someone who has never managed to qualify for that right of permanent residence. Because the short periods of, for example, being a worker, have been curtailed, have been brought to an end by reason of absence, by reason of non-compliance, or by reason of imprisonment. On my learned friend's approach, that less level of integration, of unsustained integration, would attract a greater degree of protection than someone who had acquired that all-important right of permanent residence. And that's inconsistent with everything that is said in Saccharidis and with the recitals 23-24 and the structure of the directive itself. That is why my learned friend simply loads too much, returning to Saccharidis, page 791, paragraph 31, which he relies, onto the language of paragraph 31, where he says what the court is doing here is rejecting the very purposive approach, which is just at pains set out, including that causative link at 25 and 24. My submission is absolutely wrong. There's no indication here at all that is rejecting its usual purposive approach, which will apply to ensure that the objects and purposes of the treaty and the rights and freedoms conferred under it are protected. Quite the opposite. What it is doing is rejecting the suggestion at 30 of the referring court that in this context the rule 16.4 applies by analogy. And it does so, as I say, not by saying there are no circumstances where you can lose that protection under Article 28.3a after 2 years. It does so by emphasising that you can lose that protection after a period of absence even less than 2 years. So my learned friend is wrong to suggest to the court that paragraph 31 reflects a rejection of the foregoing purposive approach outlined. Of course, he is right to say that the whole point of the right of permanent residence is to relieve the person who enjoys it from the need to continue to comply with the conditions of Article 7. So once you have that right of permanent residence acquired, all you need to do to reside legally under the directive is to reside. There's no further preconditions, whether they relate to social assistance, whether they relate to being a worker or a student or anything of that kind. Just simply continuing to exercise that right and not departing for more than 2 consecutive years is enough to mean that when you reside, you are residing legally. That's all it takes, pursuant to your right. There is that distinction, and he's absolutely right to point to the fact, but that doesn't mean that any residence will do. Still less does it mean that the importance of the right of permanent residence, once acquired, or need not even be acquired, falls away. So that's the second point. I think I'm out of time. If the court will indulge, I'll cut out one point completely to save time. Simply to refer to the close of my learned friend's submissions on the question of proportionality. We had some reference to Surinder Singh and so forth. All of this simply emphasises that there has not yet been, as is now conceded, a proper proportionality assessment. If there were qualitative elements of FV's residence linked with the Surinder Singh principle which arise, then they would fall to be considered in the context of the proportionality assessment, which must now be undertaken and would have to be undertaken whatever the threshold, whatever paragraph of Article 28 we are under. The points that were made simply don't add anything to the issues with which my lords are concerned. And nor, finally, does Article 13.1 of the directive, the provision relating to divorced persons, because as you will see when you turn it up, the second sub-paragraph of Article 13.1 expressly makes a continued right of residence after divorce still contingent and conditional upon fulfilment of the Article 7.1 condition up to the point where the right of permanent residence is acquired. The result of that is you don't get kicked out on your ear if you divorce. You have a chance to remain, but then you're treated as any other union citizen. You have to remain exercising rights under Article 7 until you qualify for the right of permanent.
Could he claim to be within any of the other heads of Article 7? I mean, could he claim to be a worker?
That depends entirely on the fact as to which we don't have any current evidence. Of course, I don't seek to disturb the conclusions. As the position in 2001, he must have qualified by one route or the other. But as to the position now, if I'm right, he has not yet acquired a permanent right of residence. Yeah. It is open to him to acquire it. He may have done so in the interim period. I don't know, and the court doesn't have evidence yet. But that would be considered by the tribunal on remittal.
So would the tribunal on any remittal be considering the correctness or propriety of the decision in 2007 to expel him, or what?
No, it would be looking at the proportionality of his removal as things stand at present, or at the time, I should say, of the tribunal's consideration. And I should also pick up in that context the question with which Lord Hughes was concerned about the ability to remove someone who does not have a right of residence. That is clear, and you'll see a reference in the 2006 regulations, Regulation 19. It's on page 583. It's 19.3a. The national who has entered the United Kingdom, or the family member of such a national who has entered the United Kingdom, may be removed if, and then there's three alternatives. A is that person does not have or ceases to have a right to reside under these regulations. B is the Secretary of State has decided that the person's removal is justified under Regulation 21. Of course, that subparagraph only arises if someone does have a right, but the Secretary of State proposes to interfere with that right for reasons of public policy, public security, or public health. That's what the right to reside means. If you don't have it, you don't get that protection because there is no interference. I'm conscious I've stretched my time. I'm very grateful.
By 3 minutes. We can cope with that. Thank you very much indeed. And thank you to everybody for their arguments, both written and oral. And we shall, as usual, take time to consider the answer. No doubt rereading MG many, many more times. Thank you. The court is now adjourned.